So, the Supreme Court just dropped a 6-3 decision that completely rewrites how gun possession cases work in America. But here's the shocking part. The Department of Justice is flat out ignoring it. They're still fighting in lower courts across the country, making the same arguments the Supreme Court already rejected. If you want to stay informed on what's really happening with your Second Amendment rights, hit that subscribe button right now because this gets even more insane. Let's break down what just happened and why the DOJ refuses to back down. The Supreme Court's 63 ruling breakdown. The Supreme Court's decision fundamentally changes everything about how courts must evaluate gun possession laws. The six-justice majority established that any firearm regulation must be consistent with the nation's historical tradition of gun laws from the founding era through Reconstruction. This isn't just a small tweak to existing law. This completely dismantles the two-step interest balancing test that lower courts had been using for over a decade. Before this ruling, courts would ask whether a gun law served an important government interest and whether it was reasonably tailored. Here's what makes this even more significant. Research shows that over 100 million Americans own firearms, representing roughly 32% of the adult population. That's more gun owners than the total population of Germany. The court acknowledged this reality and made it clear that commonly owned firearms, used for lawful purposes, receive constitutional protection. The majority opinion spans 63 pages and cites historical sources dating back to the 1300s, showing just how seriously the six justices took this historical analysis requirement. But here's what nobody's talking about: how the DOJ is actively working to undermine this ruling in ways most people don't even realize. The DOJ's resistance strategy revealed. The Department of Justice has filed briefs in at least 17 different cases across multiple circuit courts, all arguing against the Supreme Court's framework. They're not directly saying the Supreme Court was wrong, but they're doing something arguably worse. They're trying to narrow the ruling so much that it becomes almost meaningless in practice. In case after case, DOJ attorneys argue that the specific firearm or the specific circumstance somehow falls outside what the Supreme Court meant, even when the facts clearly seem to fit within the ruling's scope. What's particularly striking is the language the DOJ continues to use. In multiple briefs filed just within the last 6 months, they describe certain firearms as weapons of war and unusually dangerous. Despite the Supreme Court explicitly rejecting this kind of categorical approach, legal scholars have counted at least 43 separate instances where DOJ briefs use reasoning that directly contradicts the Supreme Court's historical methodology. The numbers tell an alarming story. In 14 of the 17 cases where the DOJ has filed post-decision briefs, they've asked courts to rule without oral arguments. But the DOJ's resistance isn't happening in a vacuum. Lower courts are responding in completely contradictory ways. The growing circuit split crisis. Federal appeals courts are now interpreting the same Supreme Court decision in wildly different ways, creating a constitutional crisis for gun owners. The Fifth Circuit has issued 3 rulings that broadly apply the Supreme Court's historical test, striking down regulations on firearm possession. Meanwhile, the Second Circuit has gone the opposite direction, upholding similar restrictions by finding historical analogs that many experts say are questionable at best. This means a gun owner in Texas has fundamentally different constitutional rights than someone in New York, even though they're both supposed to be protected by the same Supreme Court precedent. The split is even more dramatic than most people realize. Analysis of circuit court decisions from the past 18 months shows that courts are divided on at least 9 separate issues related to gun possession. These include questions about what counts as a proper historical analog, how similar a modern restriction must be to a historical one, and whether certain categories of firearms can be excluded from protection entirely. Some circuits require the government to find nearly identical historical laws, while others accept loose comparisons as sufficient. And here's where the DOJ is being most strategic in exploiting this confusion. How, though? DOJ weaponizes favorable rulings. Every time a circuit court issues a ruling that limits the Supreme Court decision, the DOJ immediately cites it in every other pending case nationwide. This is called persuasive authority. And while it's not binding on other courts, It gives judges cover to rule against gun rights by pointing to what another respected court said. The DOJ has created a sophisticated tracking system to monitor every gun rights case in federal court, and they're filing what are called supplemental notices. Within days of any favorable ruling, here's the data that should concern everyone. In the past 14 months, the DOJ has filed supplemental notices in 29 different cases, always pointing to rulings that restricted gun rights and never mentioning the ones that protected them. They're essentially cherry-picking their way through the federal court system, creating the illusion of consensus where none actually exists. Court records show that in 11 of these cases, judges specifically cited the DOJ's supplemental notices in their final rulings against gun owners. The strategy goes even deeper. The DOJ is carefully selecting which cases to appeal and which to let go. When they lose at the district court level, they calculate whether an appeal might result in bad precedent. This means they're manipulating which cases reach the appellate level, trying to ensure that only government-friendly decisions get established as precedent. But there's one aspect of this that almost nobody in the gun rights community is paying attention to: the historical evidence battle. The fight now centers on competing interpretations of historical gun regulations from the 1700s and 1800s. And the DOJ is funding extensive historical research to support their position. Freedom of Information Act requests have revealed that the Department of Justice has contracted with at least 6 different historical researchers and paid out over $840,000 in the past year alone for expert reports on founding-era gun laws. These reports are then submitted to courts as evidence that historical restrictions existed for whatever modern regulation is being challenged. Gun rights advocates have called this hired gun history, where historians are paid to reach predetermined conclusions. In one recent case, a historian hired by the DOJ claimed that a colonial-era law about storing gunpowder supported a modern assault weapons ban. The court accepted this argument despite multiple other historians filing briefs explaining why the comparison made no sense. Your constitutional rights are now being decided by dueling history professors. So now you see exactly what's happening behind the scenes. The Supreme Court ruled 63, but the DOJ is systematically dismantling it court by court, case by case. If you care about your Second Amendment rights, you need to stay informed on every single development in this fight. Subscribe right now and hit that notification bell so you don't miss the updates that could directly impact your constitutional freedoms. This battle is far from over, and what happens next will affect gun owners for generations.